All right, welcome back to another episode of Empowered Esquire TV. So, as you can see from the title of this video, today we are going to be discussing the potential Supreme Court Justice Ketanji Brown Jackson. So, as everyone comes on into the room, I want to kind of give you the lay of the land for today's show because it will be a call-in show, which means that things will be a tad bit different from what you usually see here on Empowered Esquire TV. Okay, so first, let me drop a little hello into the chat. I want to sign into the chat from YouTube to make sure that everything is functioning as it should. Let me say hello to you all. Hello, everyone. Hello to the beautiful Bernice who is in the building. Thank you for checking in with us, beautiful Bernice. Alrighty, so it looks like the chat is working well. Everything's functioning. So let's have a little preliminary chat, as I said, on how the lay of the land is going to work for this show in particular. So, we're first going to discuss what actually matters about Judge Brown Jackson. Now, as I'm sure you have seen, a lot of people have been discussing Judge Jackson, right? But here is the problem: no one is discussing what actually matters. Hence, my little message to you all in the community tab where I told you, let's have a real conversation, right? So I prefaced in my last show when I talked about Trey Songz and someone brought up Judge Jackson, I prefaced that we tend to focus on things that do not matter, which means that we are not addressing the things that do matter. Okay, so taking you back to that conversation a bit, I kind of enlightened everyone and told you that what matters, especially when it comes to a judge, is their judicial record, right? Opinions that they have published, past decisions that they've made. If that person was a prosecutor prior to becoming a judge, then their prosecutorial record. And if that person was a public defender, then their history or career as a public defender. Also, if that person was at any point a civil litigator, their reputation and career as a civil litigator. So the gist of it is what actually matters is not the person's personal life, which is what everyone has been discussing about Judge Jackson. What actually matters is their professional life and professional decisions. That is what is going to matter when that person, if slash when, right, that person takes the bench and is in a position where they're making decisions that are going to affect us all. Okay. So, hello to Nkrumah Toure. We are going to head on into our conversation about Judge Brown Jackson's background and her career. We may touch on little points of her personal life, but only those points that are actually relevant to the kind of judge that she could be. Okay, now one more point I want to mention to you all. There are two types of judges, right? There are those that are what you would call judicial activists, which means that they tend to view the bench as a way that they can change and mold and shape society, right? And then there are those judges who are more conservative in their rulings. There are those judges who some would call conservatists, right? Or purist. And they believe that it is not their role to change society or push society in one way or the other, but rather they believe that it is their role to simply interpret the law. Now, as we go through Judge Jackson's career and her history, you probably will develop an opinion as to whether or not she's an activist or a purist, right? And for background, usually your more politically conservative judges are your more judicial purist, right? So a Clarence Thomas or a Scalia, Thomas Scalia, I believe was his first name, they would usually be purist, right? Whereas a Sotomayor or a Ginsburg is probably going to be more of an activist, okay? So let's dive into Judge Jackson's background and history. And after we do so, I will provide the StreamYard link For anyone who wants to come backstage, hop onto the live and ask me any questions that you have. Okay, so let's get into it. I'm going to share my screen because I want to give you a visual of Judge Jackson as we go through her history. Alrighty, so you should have a nice little visual. This is just some visual aura, if you will, of Judge Jackson. Okay, now let us get into her background. Alrighty, so Ketanji Brown Jackson grew up in Miami, Florida, and she graduated from Miami Palmetto Senior High School in 1988. In her senior year, she won the national oratory title at the National Catholic Forensic League Championships in New Orleans, the second largest high school debate tournament in the United States. Now, I want to take a moment and talk to you about this portion of her background, okay? Just for grins and giggles, but also for the purpose of kind of telling you where my insight comes from. I also am a girl who grew up in South Florida. Palmetto High School is a high school that my high school very often had projects and played games against and things like that, right? So I have some background there. And I was a forensic league slash debate nerd in high school and in college. So I know a lot more about the forensic league than your average person. So usually when people hear forensic league, they think that it's something to do with science, right? Forensics. No. In high school and college, speech and debate is referred to as forensics. And so you have your National Forensics League, you have your Forensics Council, you have different colleges that throw forensics tournaments and forensics competitions. And when you hear forensics used in this way, it actually means speech and debate, not, forensic science, as many think. So this portion of Jackson's background is so important. Here's why. First, it tells you that she has a background in public speaking. Now, there are many, 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 many judges who do not have a background in public speaking. And a person with a background in public speaking develops some very important things. First, self-confidence, right? Second, the ability to speak persuasively. And third, the ability to speak effectively. So you already know that you're dealing with a woman who has stretching all the way back to her high school years, a woman who has a lot of experience in public speaking. And that's a very good thing for someone who would sit on the bench, right? It means that she can articulate herself well. Now, her coming from South Florida is also very important to note because for those of you who are unfamiliar with the dynamics in South Florida, there is a big rift between African Americans and or Black people and Hispanic Americans and or people of Hispanic descent in the Miami area. That has always been a problem and it is still a problem. Please do not be fooled by the City Girls and Cardi B being whatever kind of fake friendship they have, right? There's a big problem there. So Judge Jackson, especially coming from the 80s, I think the problem was worse back then than it is now. So Judge Jackson comes from a background where she probably firsthand experienced a lot of this rift and probably experienced a lot of discrimination and hardship as she was coming up in that area as a Black woman whom, as you can see, presents and has the phenotype of an African. So something interesting to note there. I want to take a moment to say hello to Doug and hello to Nappy Yankee. And as Nappy Yankee is so eloquently saying, peace to the chat. All right. And you're welcome to support the channel via Cash App if you feel called to do so. Okay. But understand that if you cannot, your presence is good enough. Okay. Alrighty, so let's dive back into Judge Jackson's background. If you have any questions about anything at any point, feel free to drop it in the chat, okay? I'm pointing out portions of her background that are actually relevant to the judge that she would be or the justice, I should say, because she's a judge, that are actually relevant to the justice that she would be were she to be placed on the Supreme Court. Okay. Point 2. So Judge Jackson attended Harvard University, where she studied government. She also was involved in improv comedy and drama during her undergraduate studies. Another important point: many lawyers have this background in improv and drama and the arts and acting, and some people do not understand the significance of that background, right? So allow me. A courtroom is very much like a stage. And so when you have a background in improv, meaning you can think on your feet, right? And then you have a background in drama and acting, meaning that you can interpret literature and create this entire world with literature, you only make yourself even more effective as an attorney. So as we're walking through her history, you can bet your bottom dollar that she is and was an effective attorney, because you see her history already: public speaking, acting, improv. This is a woman who can think on her feet, right? So that says a lot about who she was/is as an attorney. But even further, right? When we get further down in our conversation, we're going to discuss the Senate and Senate confirmation hearings. And I'm going to make a little bit of a prediction-ish, right, about how well she'll hold up in those hearings. But you're going to start piecing that together as we talk about her history, okay? All right, so Swan X. Swan X says, I was the first person here waiting for you and you have not said hello. Swan X, I don't see you in the chat. So if you did say something in the chat earlier, for some reason, it did not register, because this is the first message that you have in this chat. So that might be a YouTube thing, right? But anywho, hello. Hello to the Jason Real Show. Thank you so much for the compliment. Glad to have you here. Peace to Doug, per usual, right? Doug, the superstar moderator. I want to say how unequivocally I appreciate you, Doug. You're amazing. Okay. Hey, to let me see a transcript. How are you, darling? All right. So let's move on. Hello to Dog Cigar Morphia. Interesting name. So let's get into the third point about her history. Remember, any questions, thoughts, just drop it in the chat. All right. So after she went to Harvard for undergrad, Judge Jackson then went to Harvard Law. Okay, so she's a double Harvard graduate. Now, let's have a quick conversation about Ivy League schools and things like that. Okay, so there is a misconception, and I am going to call it a misconception. There is a misconception that because someone graduated from an Ivy League school, they are automatically more intelligent than someone who did not attend an Ivy League school. Let me go ahead and tell you right now, that is false. There are many reasons why someone may not go to an Ivy League, right? Someone may get into an Ivy League and choose not to go. And I'm going to tell you one of the biggest reasons right now: money. Many people are accepted into Ivy League schools and then do not attend those schools because the cost is just too high, right? And you may have a smaller school that will give you more scholarship funds than, say, a Harvard or a Princeton. So understand that going to an Ivy League school is not a signifier of intelligence. Now let's talk about education. Going to an Ivy League school is also not a signifier that somehow this person has a better education. That is also a misconception. Remember that education is specialized. So it depends on what school you attend for what you are studying. Case in point, there are many smaller schools in Florida that are specialized in marine biology because, Florida is surrounded by water, right? So if someone were to go to, I don't know, Georgetown, right, and study marine biology, they would not have a better education than someone who went to University of Florida or University of West Florida, right? And studied marine biology. The person from the Florida public school would have a better education than the person from Georgetown. So remember that the name is not what's relevant. It's, did you go to a school that in your specialization, they are the best that they could be? Okay. And I say that because many people get caught up on, the name of a school and they think that it signifies something, and that is not always true. Now, in terms of the Supreme Court, many of the justices did go to Ivy League schools, many of them, right? But not all of them. Okay. There are some justices, and I'm not going to quote which ones because I don't want to be wrong on that and kind of lead you astray. But I will say that I believe, don't quote me on this, but I believe that Sotomayor did not go to an Ivy League. And I think there's one or two other justices that are not Ivy League either. Okay, so keep those things in mind. And Kruma Toure says, I agree, counselor. I finished at University of Phoenix and proud of it. Everybody, let's say congratulations to Nkrumah Toure. Yes, you should be proud of your education. Okay. And don't get fooled by the name of the school. All righty. So she went to Harvard Law School. Okay. Interesting. Now, what that does mean is that she built certain connections, probably as a double Harvard grad, right? That benefited her moving forward. And here's how we see that. So she then began her career as a judicial clerk. Okay. Now she had a clerkship with Judge Justice Stephen Breyer, right? Let's talk about what clerkships are. So, if you are at all familiar with a judicial clerkship and what it is, put a Y in the chat. Hello to Health Light. Long time no see, Health Light. How are you? If you are familiar with a judicial clerkship and what that is, put a Y in the chat. If you are not, put an N in the chat. All right. So Y in the chat if you're familiar with judicial clerkships. And if you are not, hello to Angela Smith. All right. So I see an N. Okay. I imagine that most of you are not going to be familiar with judicial clerkships, and I'll tell you why. It's not something that people talk about. Okay. So let me talk to you about a judicial clerkship and what it means. So when you see that Judge Jackson clerked for Justice Breyer, what does that mean? Right? What does that mean? Okay, so I'm wrong on Sotomayor. Sotomayor did go to an Ivy League school. So let me Google it. Because there are at least two justices that did not go to Ivy League schools, but I need to remember if they are sitting justices or not. Let's see. I'm actually going to take the second now to look it up. Oh, here we go. List of law schools attended. Okay. All right, I see. Now I'm trying to see if there are current SCOTUSes, and I believe there's at least one or two current justices who did not go to an Ivy League. Let's see. I'm looking at a list now. Of course, there's a lot of Harvard and Yale. We know that, right? University of Michigan Law School, Albany Law School, Cincinnati Law School, interesting, Cumberland Law School, Indiana University Law School, Northwestern Law School, University of Virginia Law School, Washington and Lee Law School. But I'll get back to you all with which current justices did not attend an Ivy League, right? We'll get back to that. All righty. So now let's talk more about judicial clerks. So when you see an opinion written by, usually I'm going to go as far as to say, right, any federal judge, So when you see an opinion published by a federal judge, you see this beautiful opinion, well written, and it explains the law. It explains why that judge made the decision that they made in this case, et cetera, et cetera. Now, you probably think that the judge who made that ruling wrote that opinion. No, that is what clerks do. So a judicial clerk does the bulk of the legal research for the a judge that they are clerking for, and they do the bulk of the legal analysis for the judge that they are clerking for, and they usually pretty much write these judicial opinions. And what the judge will do is they will take what was written by the clerk, they will add some flowery language here or there. They'll switch some things around to make it more of their voice, their style of writing. And then boom, there goes their opinion. So really a judicial clerk does the grunt work for the judge. Okay, so when you think clerk, think think grunt worker, really. You know, the bulk of the legal research, legal writing, analysis, all of these things is going to be done by the judicial clerk. Now, it is considered an honor for an attorney to clerk for a federal judge, right? It's considered to be um a a rite of passage, if you will, right? You'll notice that a lot of judges were previously a judicial clerk because it is seen as a way that you earn your stripes. And also you network, right? You get on the good side of a judge who can later on recommend you to become a judge. Okay, so yeah, that is what a clerk does. And many people do not know that. Many people see these opinions published and they think that the judge really sat there and wrote that. And very often they did not write that. They made it flowery, right? They made it fancy, but the work that went into that opinion is usually completed by the clerk. Okay. All right, so I'm hopping in the chat. So, hello to Asaru Amunre. You are excused. Thank you for joining us. All right, let me see. Your transcript says it's Justice Amy Coney Barrett that didn't go to an Ivy League. Okay, so she's probably the current justice that did not go to an Ivy League, but there is a whole slew in the history of SCOTUS. There is a slew of justices. And when I say SCOTUS, I mean Supreme Court of the United States. That's lawyer slang for you. But in the history of SCOTUS, there are many justices that did not go to Ivy League schools. So it is absolutely not a requirement. Okay. Asaru, thank you so much for the compliment, right? Asaru flattering me, and I certainly appreciate it. Hello to Ebony Woods. How are you, Ebony Woods? Nice to see you. All righty. So now that we know what a judicial clerk is, we know exactly what it is that Judge Jackson did for Justice Breyer. Now, why is that important? Well, it tells you a number of things about Judge Jackson. First of all, whenever you are researching a politician or a judge, I want you to watch their progression. You need to be able to see, think of a person's career as a staircase, right? And I want to train you to see each stair. If you do not see each step on the staircase, you have a problem. So thus far with Judge Jackson, we see each step, right? We see Harvard undergrad, Harvard law, clerking for a justice. We're seeing each step she's taking. When you look at a judge or a politician and you do not see each step they take, what do I mean by that? I mean that if you see a judge or a politician that went from no one to senator, no one to federal judge, and you don't see each step, you have a problem. You have a problem because that tells you they did not work their way up to that position, did they? Okay, they got there some other way. I'm going to leave it at that. So it's a good thing when you see someone that you can see each step. You can see each step. Okay. Now, let me see your transcript as to most justices. I mean, you can look at the stats. My argument, or rather my statement, I should say, was not that most of them did not, but it was rather that all of them did not, right? There's a difference there. Now let's hop into the fourth point, okay? So after she clerked for Justice Breyer, right, you see that Judge Jackson then moved on to legal practice. She worked first at Goodwin Procter from 2000 to 2002, and then she moved on to another firm which was then referred to as the Feinberg Group. So let's start with Goodwin Procter, okay? Goodwin Procter is a very, very large firm, and they are known for representing and advising very large corporations, as of most recently, tech corporations. So, just to give you kind of some insight, she left clerking for a judge, right? And she moved into private practice, and she moved into corporate law, where she was probably representing large corporations. So you want to understand that progression, because that means, again, that at each step in her staircase, right, she's picking up different tools of the trade. She's picking up different perspectives. She's picking up different bits and pieces of information. And being that she has represented large corporations before, you know that it might be likely that she knows the ins and outs of these corporations. It might be likely that she has a relationship with these corporations from representing them in the past. Now, is it guaranteed? No, right? No, it's not guaranteed that she built any connection with them, but it's likely. And that is something that may or may not affect her decision making on the bench. So that is why these things are so important. Okay. Did I see Mara Sharice in here? Hello, Mara Sharice. How are you? Oh, you are a mod. I was gonna say, how are you not a mod, Mara Sharice? But you are. You are. Okay. All right. So let's see. What I think I missed something from Asaru, because he made a statement. According to the US and Oregon, for example, established jurisdiction only over public employees. Asaru, who are you speaking to? I don't think you're speaking to me, so you may need to clarify for us. Okay. Alrighty, so let's hop back into Judge Jackson's career. So she went from Goodwin Procter to the Feinberg Group, which is now Feinberg and Rosen. But I think even Feinberg and Rosen is defunct now, but that's another conversation. Okay. The Feinberg Group had a similar practice: commercial law, representing large corporations, and they also took a lot of product liability cases in which they were usually on the side of the corporation. So, for example, let's say that Tylenol sold several bottles of Tylenol that ended up causing cancer, right? Judge Brown may be an attorney that was assigned to represent Tylenol. Okay, so I'm just giving you a very simple example of the kind of work she was doing. Again, something important to keep in mind, because it may or may not have impressed on her certain ideologies, certain ideas and opinions, and certain relationships and connections to these corporations that she may or may not still be fostering and keeping today. That is why it is important. Okay, everyone? Now let's keep on moving through her career. So she then moves from private practice into working as special counsel to the United States Sentencing Commission. Okay. While there, she was there from 2003 to 2005. So just for a couple years. So you hear that, right? You hear assistant special counsel to the United States Sentencing Commission. And you probably just heard blah 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 blah, right? Like the like when you watch Charlie Brown. So let me break that down for you. So special counsel, whenever you see special counsel, it means that this person was in some sort of investigative role. It is used to refer to an attorney who isn't necessarily acting as an attorney, but rather they're acting as an investigator. So, in other words, she was hired by the United States Sentencing Commission, which is exactly as it sounds in name, right? It is a commission that is a part of the judicial branch of the US government, which researches and drafts our federal sentencing guidelines. So she was really an investigator for the commission of the judicial branch that decides, well, what are our sentencing guidelines? If someone commits this crime, then what is the minimum sentence? If someone commits that crime, what is the maximum sentence, right? And so she worked as an investigator for that commission, which, again, as far as her career, is a logical progression. It's another step in her staircase, which is a good sign, right? We can see that she worked her way up. Remember, you want to be concerned when you don't see how somebody worked their way up, right? I'm not going to say any names. I'm not going to bias you. But I want you to do your research on some of your prominent politicians because they don't have the steps in the staircase. Many of your prominent politicians went from nobody to senator. That's a problem. That is a problem because that means that some mighty hand, right, reached down into the nothingness they were in, pulled them out, and made them a senator. And that's scary. Okay. So this is good. We can see each step in her staircase. Now, what does it tell us about her as an attorney slash judge, right? It tells us that she has a very intimate knowledge of criminal sentencing. She probably knows the federal sentencing guidelines better than really almost any practicing attorney out there. And that will be good when she, if ever, right, she takes the bench of SCOTUS and they get a writ of certiorari or decide to review a criminal case. That would be good because they will have a justice who has a very, very intimate knowledge of federal sentencing. That's a good thing. Okay. All righty. Hello to Miss Jams. How are ya? Hello to, did I miss someone? No, I think I got everyone now. um, Asaru says, this is good. Thank you, thank you, thank you. Everyone, hit the like button. If you agree with Asaru, hit the like button. It's free and it'll help us rank in the in this algorithm so that more people can get this information, you all. We need to be talking about the right things. We need to be discussing the career, the judicial record. These are the things we need to dissect, y'all, not someone's spouse and their children. Let's bring some respectability and logic to this conversation. And you're a part of that. You, as a viewer of this channel, being on this live stream right now, just simply by hitting the like button, you can encourage everyone to have a more respectable, logical conversation about Judge Jackson. This is it. You're a part of that. You're a part of the solution. Whereas we're so used to hearing about problems, we don't really talk about the solution. Y'all, the solution is to have the right discussion. And we are having the right discussion. So listen, like this video, share this video, subscribe to this channel. Let's have the right conversation. Okay, writ of certiorari. Thank you for reminding me, Amun Ray, when we get down later on into our conversation, remind me again, and I'll walk you all through what a writ of certiorari is. I actually am partnering with another attorney to write one as we speak, okay? All righty. Hello to Kofi. Thank you for joining us from Central America. How are you? All right. Kofi just reminded me, let me take a second and do my content creator roundup. Okay, everyone check out the beautiful Bernice. She's a content creator here on YouTube. Check out Nappy Yankee. He's a content creator here on YouTube. Check out Let Me See Your Transcript. Check out the Jason Real Show. I'm missing some people. Hold on. I'm working my way through. Nappy Yankee. I believe that's it, right? Until we get to Kofi, okay? And check out Kofi. Oh, wait, Diva's here. Hi, Diva. Check out Diva Divine Light. Okay, she's also a content creator here on YouTube. So everyone, check out these content creators, all right? Yes, Diva, I have been a busy bee, but I texted you the other day. I don't know if you got it, but I'll try again. But yes, I have been a busy bee. All right. And everyone, if you want to support the channel, Doug, as always, is telling you how to do that. Let me pin his comment so that it's there if you want that info. Okay. And hello to Christopher Quintero. I see you. So let's dive back into Judge Jackson's career, shall we? Let's get back into it. Okay. So she went from special counsel for the United States Sentencing Commission, which we discussed what that is, to being an assistant federal public defender in DC. And we see that she did that for a couple years, right? So we see another step in the staircase. Now, notice that everything Judge Jackson does is 2 years here, 3 years there, 2 years here, 3 years there, right? That also tells you something, people. It tells you that she is a woman with ambition, right? Because she knows, she sees the staircase just like we do. And she's purposely working her way up, right? She goes one step, couple of years. So it looks okay on my resume. Okay, next step, couple of years. So it looks okay on my resume. Okay, next step, right? She's an ambitious woman. She may be, possibly, maybe allegedly, always wanted to be on the Supreme Court. She maybe crafted her entire career to get to this moment. All right. Let's continue. So, as a federal public defender in Washington, D.C., you can imagine that she probably had quite a strenuous caseload, which tells you that she is used to having high demands on her, right? And she's, again, a woman, a judge, an attorney who has an intimate knowledge of criminal law, which is good. Okay. Now, I do want to note that you'll see that many people have developed an opinion of Judge Jackson based upon her being a federal public defender. Allow me to once more take those assumptions that you may have developed, right, and kind of tear them asunder, right? Allow me. Many people think that that because someone was previously a public defender, they are liberal. Allow me to disavow you of that assumption. I personally know many previous public defenders who, after being a public defender, they may publicly exhibit that they are liberal, meaning publicly they will tell people they're liberal, but in quiet, they are actually conservative. And that is because public defenders tend to see a lot of things about certain demographics, follow me here, right, that lead them to be conservative. So do not make the assumption that she's liberal just because she used to be a public defender. Okay? Keep that in mind. I'm not saying she isn't liberal. I'm not saying that. I'm walking you through her career and I am telling you what could or could not be based upon what we're seeing and encouraging you to do your own research and not to make assumptions. Okay. All right, let's move on. So we then see that she, in 2013, was nominated to be a federal judge, right? She was nominated for the United States District Court for the District of Columbia by President Barack Obama. Uh-huh. So now we see another step in her staircase. We see that she went from being a clerk to private practice to working for the judiciary as a investigative counsel, right? To public defender to a district court judge. Now, for those of you who are not familiar with the inner workings of the judiciary, right? One would begin as a judge of, say, a district court, which is a lower court. And then you would work your way into an appeals court. And then from there, possibly go to an even higher court, such as SCOTUS, right? Okay, so again, we see another step in her staircase, and we know her history. We know that she was nominated by nominated by President Barack Obama, which does tell you that probably former President Obama felt that he and Judge Jackson had a lot of things in common. He probably felt that ideologically they had commonalities, and that is what led him to nominate her. Okay. Now, the next step in her staircase. In 2021, she was nominated to the United States Court of Appeals for the District of Columbia Circuit by President Joe Biden. So we see that she was a lower court or district court judge from 2013 until 2021. Again, what does that tell us, everyone? It tells us that she took the requisite steps in the staircase. It tells us that at the very least, even if you don't necessarily agree with her ideologies, you see the work that she's put in. You see that she has extensive experience in her practice. She has been a judge not since yesterday, y'all, right? She has been a judge since 2013. So, agree with her ideology or not, again, we see the staircase, we see each step in the staircase. That's not alarming. Remember what I told you is alarming, right? When you don't see the steps in the staircase. Okay. All right. So now we know that she's currently sitting on the Court of Appeals for the District of Columbia Circuit. Okay. So let's talk about that, shall we? So she is currently a part of the District of Columbia Circuit Judicial Council. What is that, you might be wondering? Well, allow me to have a little chat with you about what that is. And while we do that, I want to pull up for you a little web page, if you will, that kind of walks you, well, not walks you through, but that kind of gives you a gist of what the Judicial Council is. And then I am, of course, going to give you more of the deets on that, right? All right, so let me open up that tab for you. And then I'm just going to stop sharing this tab so I can share that tab, right? All righty. Should do stop sharing. Perfect. Sharing my screen. Let's start here. Let's start with the names of the council, and then we'll move on to the purpose. Okay. So currently here on the Circuit Judicial Council, you have Judge Jackson, as well as the Chief Judge, I'm going to mess that up, Judge Gregory Katsas, Judge Rao, Judge Walker, Judge Howell, Judge Contreras, Judge Cooper, and Judge Chutkin. So those are all of the judges currently on the Circuit Judicial Council. Now, let's talk about what that council does, shall we? Okay. All right. So here we are. So the primary function of the Circuit Judicial Council is to improve the administration of justice within the circuit by acting on issues that affect the internal operations of the entire circuit. Aha! What does that mean, you all? Allow me. It is a fancy way of saying they are the internal affairs for the judges in DC. Meaning, if a judge in DC allegedly does something they should not be doing, they act as the reviewing board of that behavior. Okay. The council is empowered by statute to make all necessary and appropriate orders for the effective and expeditious administration of justice within its circuit. Within this broad grant of supervisory power, the council has two important mandates. One, formulation of circuit policy and implementation of policy derivatives. And two, from the United States Judicial Conference, and in some instances from Congress. Okay. The law provides that councils must consist of the chief judge of the Court of Appeals and an equal number of circuit and district court judges. Note this. Note that this is the equivalent of internal affairs for judges, right? This is the way that the judges police themselves. And they must have a chief judge of the Court of Appeals and then also some lower court judges thrown in there as well. So this is a council of judges from the different levels of court in DC that they act as the review board for the conduct of themselves, pretty much, right? You're reporting a judge to a judge. So let's talk about how that works. Now, I'm sure you're thinking that there is really no other sector of our government in which you report someone to themselves. Well, there is law enforcement. When the police do something wrong, very often you report the police to the police. And that is the same thing with the judiciary. When a judge does something quote unquote wrong, you file a complaint of misconduct to another judge. You report a judge to a judge. Now, again, I'm not going to bias you, right? I want you to develop your own opinions. So, develop your own opinion about the impartiality of reporting a judge to another judge. Let's further our conversation about that, shall we? So, you all know that attorneys talk, right? Just like if you're an accountant, accountants talk. Just like if you're a cosmetologist, cosmetologists talk, which means that an attorney will kind of share this experience with that attorney who will then pass it on to that attorney and then talk to that attorney and call, and that is how we share experiences. Okay? So keep that in mind. Allegedly, the District of Columbia Circuit Judicial Council allegedly is notorious for arbitrarily dismissing misconduct complaints without providing a reason for the dismissal. Okay. And so people have alleged that this council is allowing the judges in DC to just do whatever they want, to participate in whatever conduct they deem to be appropriate. And there are some people on the ground in DC who have expressed that they do not think that this setup is working, that they believe that the judges in DC are running amok and no one is stopping it. Okay, that's all allegedly. All right. Hello to Tyrus Thomas. How are you? Okay. Hello to Karen J. Good evening to you. Okay. And as Doug has reminded us, if you want to support the channel, you may do so via Cash App, or you can do the free option, which is just hitting the like button. Okay. That also supports the channel. So, we know what Judge Brown is up to at this moment, right? We know that she's on appeals. She sits on the appeals court in DC, and we know that she also is a part of this judicial council, which we just had an interesting combo about. Okay. Now let's talk a bit about her nomination. I have an article, an interesting article that I want to share with you all, and I want to get your thoughts on this article. I want us to start, getting into the conversation about what you think about this, okay? Hello to Fab 540. How are you? All right. Let me share my screen so we can hop into this next article and have a conversation about this. All right. So, as you can see from the title of this article, Alabama's first Black federal judge is asking Biden not to nominate Ketanji Brown Jackson for the Supreme Court. Ouch. Okay. All right. So keep in mind what we read about Judge Brown's career, right? We see the staircase. So it's not likely that this judge argued that she did not deserve it per se, right? So let's see what it is that this judge was, upset about, why this Black judge does not want Ketanji Brown Jackson to be a Supreme Court justice. All right, here we go. So, the first Black federal judge in Alabama sent a letter to President Joe Biden asking him to pass over a leading contender for the United States Supreme Court. U.W. Clement, a former state lawmaker who served as a federal judge in Alabama from 1980 to 2009, petitioned the president not to consider Judge Ketanji Brown Jackson for the vacancy that will be filed upon the departure of Justice Breyer later this year. Aha! Uh-huh. You guys like how I held on to that for you? I want you to take a moment here. Who did Judge Jackson clerk for? Who did she clerk for, everyone? When she was a clerk, who did she clerk for? Someone drop in the chat the last name of the judge that she clerked for. And I held on to it until now so that I could make this connection with you. You know, it's like when you flip the switch and the light bulb goes, oh, the light bulb comes on. Who did Judge Brown Jackson clerk for? What judge was she a judicial clerk for, everyone? Aha! Thank you, Smith Emily. She was a judicial clerk for Justice Breyer. So now his seat is vacant and she is nominated to take his seat. Now, I want to say to you, do you think that's a coincidence? Do you think it's a coincidence that she clerked for him and now he's leaving his seat and she's taking his seat? I want you to see how this works because we discussed the steps in the staircase, right? But when I talked about judicial clerkship, I told you it's a rite of passage, it's a means of networking, right? This is why many people who know they want to be a judge will clerk for a judge because they know they are building that bond. And that when the time comes, the judge will tell the powers that be, hey, that's the person that I want to take my seat. And I'm not going to get out of my seat unless you give it to this person. Okay. All righty. Let's continue. Now, in his letter, Clemens said there were several exceptionally well qualified Black female aspirants for the Supreme Court, but expressed a desire to see Jackson out of the contention for the nomination. The retired judge pointed to the case of Ross v. Lockheed, a 2016 class action lawsuit brought forward on behalf of 5,500 Black Lockheed Martin employees as the basis for his opposition to Jackson's potential nomination. Okay, let's take a breather. So it looks like Clement is not just saying that he doesn't like her ideology, right? He's pointing to a specific decision that she made that I believe he's going to articulate for us, right? Why this decision could make her a problem on the Supreme Court. Okay, so he is saying that there was a specific decision she made back in 2016 that he views to be problematic. Let's continue. So Jackson presided over the case, and Clemens said that Jackson failed to greenlight the settlement that was reached, which was set to disperse $22 million to the employees. Clemens then went on to explain she refused to approve the settlement because, in her view, there were no common factual questions. He continued by saying, Judge Jackson gave the axe to a settlement designed to benefit Black workers at one of the nation's largest employers, denied the injunctive relief agreed to by Lockheed Martin that would have addressed a root cause of systemic racial bias that could have been a model for a nation hungry for racial equity solutions, and denied the Black workers the right to seek evidence to prove their claim of company-wide racial discrimination, and knowingly frustrated the rights of Black workers to appeal her decision. Now we are getting into it, aren't we? Now, we've discussed class action before, have we not? Right? If you're an OG. But if you're a newbie, class action is probably all new to you, right? So allow me to take you on a little walk down class action lane. So, a class action lawsuit is a lawsuit that is filed by a large number of people, sometimes so many people that you can't even list them all, right? But in order for a class to file a class action, they have to be what? A class. Aha, right? So, of course, the federal rules have denoted what you have to have in common for you to be a class. So, there are things that a group of people have to have in common for them to be a class. And then, if they have these things in common, then they are a class which can file a class action lawsuit. So, one of those things is some common question of fact and some common question of law. Now, usually employment discrimination is, a class action, right? There are so many employment discrimination cases that are class action, similar to product liability and things like that. There are many cases, I mean, too many to count, right? Where a number of African American employees of a certain company have gotten together and sued that company as a class. Now, they're going to have common questions of law because they're all alleging racial discrimination. And they're going to have common questions of fact because they're alleging that based upon whatever policies exist in that company, discrimination is resulting. So the questions of fact as to whether these policies exist, how these policies are applied, right? Those are all common questions of fact. So in this case, it is very likely that all of these Black employees were filing as a class because they were first saying, listen, we're all being discriminated against because we are African American. That violates the Civil Rights Act, right? They were probably saying, listen, these are the policies and these are the actions of Lockheed Martin that are discriminatory. So that was probably their argument for why they should be considered to be a class. Now, here is what you're hearing. What you're hearing is that there was a settlement reached, meaning Lockheed Martin got together with this class and they came up with an agreement. When that happens, when you have a class and a defendant who comes up with an agreement, they can't just, ride off into the sunset. They have to get approval from the judge, the presiding judge. So Lockheed Martin and this class of African American workers who said they had been discriminated against, they reached a settlement together. They came up with an agreement. They then went to Judge Brown Jackson and said, hey, Judge, hey, listen, we came up with a settlement. We've reached an agreement. Judge Brown Jackson then says, no, I do not agree with the settlement because I do not think that all of these people have questions of fact in common, meaning I don't think these people are a class. Okay? Now, Beach Waves is saying something that is defensive, but interesting. So Beach Wave says, okay, one case, what else? Are we also looking at the cases of this Alabama judge? We're not talking about the Alabama judge because that's not the person that's nominated for the Supreme Court. And as I always say to you all when we discuss these topics, you should not be defensive because it's not you. You should be able to view all of these topics from both perspectives. So just as I said that she had this illustrious career where you could see each step in the staircase and you could see how experienced she is, and I'm sure you received that well, right? You should also be able to receive this article. You should be impartial in your investigation of her, not defensive and already taking a side, because that cuts you off from information. That keeps you back. That holds you down, not me or anybody else, right? You have to be able to view someone as a whole. And it doesn't mean you hate them. It doesn't mean you're attacking them. It means you are seeking impartial information. So just as we can praise her steps in the staircase, we should be able to read this article as well. Okay. I'm glad we had that combo though. Thank you, Beach Waves, for that moment. Because sometimes we need to have that moment, right? Where you remember that this is not your mommy, right? We're not attacking your family member. And we're not attacking her at all, right? But sometimes we gotta have that moment. Hey, listen, people, you need to impartially and neutrally view every side of the spectrum. You cannot walk into these situations already having a chip on your shoulder and having your mind made up, because then you're closed off. You're closed off. Then you are not open to information. And my goodness, people, there is nothing more tragic than closing yourself off from information that is available. Right. So actually, thank you a lot to Beach Waves, because I'm glad that we had that moment. So thank you, Beach Waves, for your contribution. Now let's move forward. All right. So he explains that she pretty much knocked the settlement down and said that they don't have questions of fact in common. And I just told you, the truth of the matter is, these type of class action lawsuits are filed all the time. Judges deem that to be a class all the time. If all of these employees are African American, they're all alleging discrimination based on race. They all worked for the same company in the same time frame. They're all alleging to be affected by the same company policy. Then my goodness, what else do you need for a class action? If that is not a class, then what is? In my humble opinion. Okay? All righty, so let's continue. Clement provided an additional warning intended to buttress his opinion of Jackson's potential influence on the court. Each of these considerations standing alone is a bell sounding the alarm that if Judge Jackson is appointed to the Supreme Court, simple justice and equality in the workplace will be sacrificed. Interesting. So it's interesting that Clement is not noting that Judge Jackson is the Antichrist, right? He's not saying that. But he's saying that she seems to exhibit some bias towards what? Corporations. I want you all to remember the conversation. Remember when we talked about her experience and we talked about how she represented some corporations in the beginning of her career? And I said, keep that in mind. That is exactly what Judge Clement is saying. He's saying that she has, an extensive career, but that he feels that, in his opinion, she is not for the average worker. And from her experience, we see that that's not too far off. Okay. Or we see that that wouldn't be too far off. Let's say that. Okay. Again, nothing that I share with you is meant to sway your opinion in any way. That is why we walk through her career. This is meant to open you up to the world of information that is out there and allow you to come to an informed decision. Okay, let's continue. So, the White House, of course, pushed back against the characterization of Jackson in Clement's letter. The White House says it's because of Judge Jackson's experience in roles at all levels of the justice system, her character, and her legal brilliance that President Biden nominated her to the DC Circuit Court, after which she earned her third Senate confirmation. And he's very proud of that decision. Okay? So that is the White House's response. Now, I want you to notice that the White House did not respond to what Clemens actually said happened. That's very interesting. Like they didn't address it at all. They just kind of gave a flowery statement. We like her. Her hair is pretty. She smells nice. Interesting. Okay. So I am back in the chats. So Mara Sharice made an interesting point. She says the Alabama judge may be fighting for his own candidate. He may be, but why not name that person? Right? Again, don't look for reasons why he may be biased. Just receive the information. Because if he was fighting for his own candidate, what's the name of his candidate? Why not drop that then? Just receive the information. Just receive. All right. So since we heard so much about this opinion, how about we look at it? How about we look at it? So first, let's look at the actual requirements for a class action, which we've looked at before, but we're going to look at again so that we can all be on the same page. All righty. So I'm pulling up the rule for class action. All right. So here we go. Let me share my screen. All right. So here we go. So class actions. Okay. Making sure you can see that. Let me do this so you can see. Perfect. Okay. So you want to have a numerous class, okay? You want to have questions of law or fact common to the class, okay? And then you want to have claims or defenses of the representative parties that are typical of the claims and defenses of the class. So in other words, you want similarity in law and or fact, right? And similarity in claims, which again, most class actions with employment discrimination that involves race, they meet these requirements. Okay. Now let's take a look at the actual opinion that, this Judge Clement was going on and on about, because obviously he feels very strongly about it, right? So why not take a look at it and see what it is that he felt so strongly about? So let's see. All righty. So apparently, oh, there we go. I thought it was frozen. Okay, it's not frozen. All right. So here we go. So the summary is that, and this is, of course, the summary of Judge Jackson's opinion. So her opinion is that plaintiffs failed to demonstrate commonality because they did not point to a testing procedure or otherwise company-wide evaluation method that can be charged with bias. Nor did they offer significant proof that an employer operated under a general policy of discrimination. Interesting. So it looks like the gist of what Judge Jackson is saying is that she did not see a specific procedure or a specific policy that these employees pointed to say, oh, this is what was discriminatory. Okay, let's dig in. Okay. Is this a really, I think it was really long, so we're not going to read this entire thing. I want us to get to her analysis, because there's just no way we're going to read through this and I want call in time. I want you guys to have time to call in. Okay. Let's read this bit about the settlement. So, on December 23rd, 2016, plaintiffs filed the class action complaint as well as their argument for why they should be deemed a class. Okay. The proposed settlement agreement provides programmatic and monetary relief to the members of the class. Okay, then. The programmatic relief primarily consists of the establishment of a council, interesting, that will recommend certain changes. So this settlement was money, programs, and a review board. This was a really okay, this was a really intricate settlement. Interesting. Okay, so now we have some details about the settlement. Let's see if we can dig more into her analysis for why she did not deem. We want a little bit more about why she did not deem this to be a class. Let's see. Let's see. Here we go. Analysis. Okay. This is what we want. Okay. Let's see why she's saying that to her, this was not a class. Okay. Plaintiffs propose to represent a class of individuals that encompasses all current and former African American employees at Lockheed who received a less than perfect performance evaluation on at least one occasion during a 3-year period. Okay. Plaintiffs maintain that there are more than 5,500 of such individuals, and they argue that their proposed class satisfies the commonality requirement because each member of the class was subject to the same performance evaluation system. Unfortunately for plaintiffs, the Supreme Court's landmark decision in Walmart Stores v. Duke spoke directly to what is required to satisfy the commonality criterion in the context of an employment discrimination class action. And its reasoning makes abundantly clear that the commonality criterion is not satisfied here. Okay, so we're getting some more insight here. So she's saying, listen, there's precedent here. And she feels that based upon the past cases, the precedent, right? Remember, precedent, case law. So Judge Jackson is saying, based upon the case law that is available to me, I don't think you all meet the requirements for a class. Okay, let's see why. So first, she's saying that to maintain an employment discrimination case as a class action, right, the employer has to discriminate against all of the class members in the same way. Interesting. Now, mind you, she's saying that all of these nuances come from this case here, this Walmart Stores Inc. v. Dukes. Okay, so I want you to keep that in mind. And the reason why you should keep that in mind is because we previously were having this back and forth about one case. This is only one case. Well, her decision is based on one case. Okay. All righty. Now I see a question. So let me see. A transcript says she didn't let them have the money, but everything else, no. She did not let them have anything in the settlement agreement because she ruled that they are not a class, which means they do not qualify for a class action settlement. All righty, let's continue. Okay, so she says, first of all, they were not all discriminated against in the same way. Okay, and then she goes into why that applies. Let's see if she has a second reason. I believe she probably does. Second, plaintiffs have not established that Lockheed's performance review system causes racially disparate outcomes. Interesting. In a manner that can be established through common proof. Okay, so first she says, listen, you weren't all discriminated against in the same way. Second, she says, listen, you have not provided enough evidence that the performance review system even caused any discriminatory effect. It seems like it could have been applied the same way for everyone. Okay. Let's see if she had a third point. Scrolling. No. Okay. Alrighty. So those were her two reasons for why they are not a class. She also argues that plaintiffs did not make a showing that the settlement is fair, reasonable, and adequate. So notice she is saying no to them on every front, right? She's saying, no, you're not a class. And she's also saying, no, you have not presented me with a settlement that is fair. So listen, for some reason, she did not think that plaintiffs provided her with enough evidence that this settlement was a fair, reasonable, and adequate settlement. That's her legal opinion. Okay. Let's continue scrolling. Okay, and then conclusion. Okay, so we have a pretty good idea here of why it is that Judge Jackson struck down this settlement. So, from what we see, it appears that Judge Jackson, first of all, said that, hey, you're not a class, right? You have not demonstrated that you were discriminated against in the same way. Second, she said to them, you haven't proved that this system was racially discriminatory in any way, right? And then next, she said to them, and you have not proved that this settlement is reasonable. Okay, so a lot to unpack there. But again, this was her legal opinion. It's important for you to know what her legal opinion was, right? Because this is the opinion that led to Judge Clement writing this, scathing letter where he's saying, I don't think she should be permitted to be SCOTUS because I think she's dangerous for workers, for employees. Okay? So listen, take that as you may, but now we know what happened. At least now we know what happened. Okay. So Diva wants to know, do you need a certain number of people? You just need more than one, right? Theoretically, you just need more than one. But of course, you have a stronger argument for class action, I would say, if you have at least 3 people. Okay. All righty. So hello to Rockin' with the Truth. All right. And Health Light, I think you need to run back the stream because we just had that combo. So run it back a bit. Hello to Societe Commentare. Peace to you as well. All right, everyone. So I'm going to throw the StreamYard link in the chat. And I'm going to invite you all to come on backstage. Of course, you see that I am not cammed up, right? And there's a reason for that, because I don't want y'all to have any excuses. You don't need to turn your camera on. Y'all always got all these questions in the comments and in the email when you email me, right? No camera needed. Audio only. Come back, come backyard, come backstage, and I'll let you onto the stream and talk to me. What are your questions? All right. What are your questions about judicial selection, about Judge Brown Jackson? And what is your opinion? Do you think that if she makes it to the bench, she will be fair and impartial? Or do you think that she's skewed either in one way or another? And if you think she's skewed, in what way do you think she's skewed? Okay. And yes, Asaru is correct. A class is a group. Okay. A class is a group. So while I wait for you all, let's have a conversation here about a writ of certiorari. Okay. So, if you want the Supreme Court to review your case for some reason, one of the ways you can do that is you can submit to the Supreme Court a writ of certiorari. It's a written, what's called a petition, right? So, it's a written document that is in the form of a petition. And you are saying to the Supreme Court, listen, Supreme Court, you are the highest court of the land. There are some things that happened in my case that were absolutely egregious. They are against constitutional law. They are against statutory law. They are illegal and unlawful, and the lower court is refusing to fix it. So, Supreme Court, I need you to review it. Now, an interesting question was asked. Now, Asaru asked the question of whether or not the Lockheed Martin case, that class of plaintiffs, whether they could have submitted a petition for a writ of certiorari, and they could have petitioned SCOTUS. Yes, they could have. However, let me find the stats for you all on how many writs are actually granted, because I'm telling you, almost none. Okay, almost none. The Supreme Court does not grant many of these requests. Okay, they just don't. All right, I think someone is backstage here. All right, we got somebody backstage. So just for some insight, okay, the Supreme Court receives approximately 7,000. Let me back that up. Let me put that into statistic form for you. Out of every 7,000 to 8,000 petitions for a writ of certiorari that SCOTUS receives, they only accept 80. One more time. Out of 7,000 to 8,000 petitions, SCOTUS will only actually accept about 80 of those. Okay? So understand that, yeah. Okay. And B Buccaneer says something I want to address. B Buccaneer says Clemens didn't mention that it was his firm that represented the plaintiffs in that case. They lost $6 million. So actually, B Buccaneer, I think he did mention that. That is mentioned in the article. And I think that is something we should consider. However, we shouldn't take that as nullifying anything that he said, because he's the person who would know enough about that case to write that letter. That it makes sense. No one else, the members of the class, would not be able to articulate that letter that way. So it makes sense that he's the person that wrote that letter. Let's see. All right, Nappy Yankee is here. I'm going to add him to the stream. So Nappy, I know you can hear me. I'm going to add you to the stream now so we can chat. All right.
Can you hear me?
We can hear you. How's it going, Nappy Yankee?
I am great. I am good.
Welcome to Empowered Esquire TV.
Yeah, this is my first time on the stage,
Yeah.
And so hopefully it's a good one, and the Sandman doesn't pull me off. But let me say this. I'm glad you brought up her background because it does give me a little bit more of an understanding of Judge J.W. Clemens, UW, I think it's UW, Clemens' concerns, because I spoke on this, and my thing is this, that obviously she grew up in, or her legally, she rised up in corporate law, from what you're saying. So obviously she's ruling for the corporation. My question is this: it's a class action suit. Class in this case would that mean black people? And isn't that what the Judge Clemens is saying? In that, when he wrote the letter, he said, "Well, she may not be good for black people because of this class action suit, which she didn't see the black people as a class." Am I, are you understanding the question?
So yes, Nappy, you pretty much said exactly the point that Judge Clement was making. So these types of cases regarding racial discrimination are the norm. The NFL is going through one right now, right? It is
Right.
very, very common for a class of people, based upon them being the same race, to file a class action lawsuit against a corporation. And very rarely, in fact, this is the first case that I've ever seen in which I see a group of people who, in which their race is the same and they're being told they're not a class. I have never even seen that before. And so when I
Yeah.
first stumbled against this article, I said, oh, wow, because I was just doing my research. Again, let me tell everyone who's watching, I researched impartially, I researched neutrally. So I just started researching her and then, stumbled across this. I have never seen a case in which a group of people who are the same race and are alleging racial discrimination are told that they are not a class. I've never
Now,
seen that before.
now, mind you, this is a black woman who's saying this. All right. So, and that's what makes it. This is what makes some people a bit wary about her. I mean, I know that the fact, who she's married to, that's not significant in the big scheme of things. But the fact that the Biden is nominating a black woman and basically making that, it seems more symbolic when here she is, a black woman in front of a case that deals with black people, and she rules in the way it does. That could be problematic when she goes to the Supreme Court. And I'm very interested to see if this is brought up during the hearings. Mind you, there were a few Republican senators that like this woman. All right. So I think that, and someone had mentioned in my comment section, they were like, she's a corporatist. Maybe that's why they like her. All right. So I do think that that's something to look at. And we know to me, and I did a video on this, that who she's married to is the least of her concerns. But the fact that she's a black woman, that shouldn't be. I've heard a lot of the commentary say, "Oh, well, this is a black woman. She's going to bring people together." We had a black president, and he didn't bring everyone together. So I think we should start looking at some of the cases that she's ruled in, especially in this case. And mind you, from what I read, I think that she presided over about 100 cases, if I'm correct. So this is one down, 99 more to go.
So I'm glad that you brought up Senate confirmation hearings because I actually wanted to discuss that. So um, let's just have a quick combo about the importance of the Senate confirmation. Remember, President Biden has nominated Judge Brown Jackson, but she cannot take that Supreme Court seat until she is confirmed by a majority vote in the Senate, right? Hence why they have these Senate confirmation hearings. Now, let me tell you, the Senate confirmation hearings we have nowadays are tame. Okay, they are tame. If you want to
Yeah.
read a real Senate confirmation hearing, look up the transcripts of Thurgood Marshall's Senate confirmation hearings.
You
I
don't
mean,
even have to go that far back. How about Bork?
but yeah, yeah. But I like that. I'm a big Thurgood Marshall fan, of course. So, and
Right.
hence why I
No, I hear
recommended
you.
it. But you'll
I
get
hear
an
you.
example of how these confirmation hearings used to be, right? When people were truly being vetted, it was extensive. and it was gruesome, right? Nowadays, it's a lot more tame. And quite frankly, by the time you make it to Senate confirmation, usually you're going to be okay. Usually. Okay. But let's talk about Judge Jackson's Senate confirmation. I think, as Nappy Yankee said, that it's likely, I think it's very likely that this case is going to come up. And it will be very interesting to hear Judge Jackson kind of, walk us through and explain, why she made the decision that she made. Now, remember, she can articulate herself, y'all. Remember this woman's career. She knows how to articulate herself. So her opinion is articulate and she walks us through why she made the decision that she made. But it will be even more interesting to hear her speak about it and also to hear her answer questions. Now, here is the thing though, Nappy. I cannot think of a single Black politician in there who is going to really ask her the questions that we would want someone to ask. And I think the white politicians, the white senators will be afraid to ask.
Unfortunately.
Right. So the questions that we really want answered, I don't know if we're going to get there because I can't think of anyone, because remember, the bulk of the people on that side of the aisle, this is their nominee. So they're not going to really ask her any of the tough questions, right? So I don't
No.
know. We will see how this.
Unless some scandal, and I'm not talking about a salacious one. It doesn't even have to be that. I mean, when you look back at Bjork, did nothing salacious came out, but they made him out to be almost Hitler. So it all unless something major comes out, and it may even extend to her family members, many of whom were in law enforcement. She mentioned about the uncle that got caught up, in the system, in the cocaine business. So something major, I guess, is going to have to come up. It looks pretty clean now, and I did notice that she jumped right in front of it as soon as she was introduced. So I think that she just wanted to kind of put it out there, but people are digging right now. So it'll be interesting to see if anything major comes up between now and when the Senate confirmations come.
Yes, it will be very, very interesting. And I love that you brought up that, a lot of people were talking about her personal life. That's part of the main reason why I did this live, because I said, wow. So I just had a weird moment. You guys know I like to have my little personality moments. So you guys know I'm from the South and I say y'all and everything, but I've been up north for a while. And I just said talk like, like a real New Yorker. Oh, yuck. Okay, talk. So not to say
Mm-hmm.
anything's wrong with New Yorkers. Love you guys.
Right.
Don't kill me.
I hear you.
So everyone was talking about, her spouse and her children. And, I was talking to someone else about her earlier, having, a personal convo. And I said to the person, I know plenty of people with white spouses, Hispanic spouses, Asian spouses who are pillars in their community, who give back, particularly to the Black community, who do work in the Black community. I said, now on the flip side, I know plenty of people with Black spouses who do nothing, contribute nothing to society and their community at large. And it's
Yeah.
the same thing with the natural hair argument, right? Many, many years ago, I heard someone say, you can have natural hair and a processed mind.
Yeah.
So that's my concern, is we were focusing on the wrong thing, right? Just because someone has natural hair does not mean they are authentically part of anything to do with their ethnicity at all. And it's the same thing with the spouse. There are many people with spouses who look the way that people may want their spouse to look, and they're of no benefit to the community.
I hear you. Well, I will say this. Like I said, I think something we got to look at some of those other cases she's done. Again, the fact that she's a Black woman, and this one case involving Black people, she ruled the way she did. I think that is something to look at as far as what her mindset's about. I know that you preach that, well, we got to look at the law, the law, the law. I do understand that, but what a lot of the advocates are saying is, oh, because she's a Black woman, that's going to she's going to be almost like she's going to be there to offset Clarence Thomas, and that's not necessarily the case. given maybe some of her rulings. So I mean, I don't look at things Republican or Democrat or what have you. I mean, a lot of it, again, it's what your mindset is. So I think that a lot of people who are advocating for her, for, let's face it, the same reason, the same superficial reasons, I think they got to look deeper into it. So that's basically what I wanted to say. And just one more thing I got to tell you, Candace and Kim Classic are moving forward with the case, it seems. So
All
that's just a
right.
little, yeah. I mean, it looks like, I mean, that has really gotten ugly, and I think that if I'm rooting for Kim, to be honest with you, but listen, it could $20 million. It's a lot of money, so just a case for you to just keep in mind, and that seems to be moving towards the courtroom.
Well, thank you, Nappy Yankee. I will be looking for that. If you all want a precursor to the Candace Owens and Kim Klacik defamation case, you can take a look at my videos. I did a video on that case way back when it was first filed, and I am the legal nerd in me is excited for that case. I will not say who I'm quote unquote rooting for, right? I don't like to impress on you, but I'm excited about that. That's going to be interesting.
Well, yeah, and another idea, you may want to, when this confirmation comes, you may want to do a live. I'm guessing everybody at your workplace will probably be live streaming it. So, it's just an idea.
Thank you very much, Nappy Yankee. So I'm going to answer this question from Quack 13. Nappy, you're welcome to stay or go. It's totally up to you. So
Yeah,
Quack 13's question is she saying that the people aren't a class because they are Black? Or did she say they weren't a class because they weren't discriminated against, or because they weren't discriminated against in the same way? So it's the latter, Quack 13. She's not saying that they aren't a class simply because they are all Black, but she's arguing that they have not presented enough evidence that they are a class, right? So she's not necessarily putting in black and white that race isn't enough to make you a class. Rather, she's stressing that they haven't they haven't presented enough additional elements to make them a class. Okay?
all right. So I'm a roll. Thanks for having me out.
Of course, go ahead. Go ahead. Thank you for joining us. I am going to put the link in the chat. Okay. If you want to come backstage and join me again, the cam is not an excuse because, as you can see, I am purposely not cammed up right now. So you're welcome to come on and just have a little audio combo with us. Okay. I see a lot of people here in the chat who are very, very vocal. So why not come onto the live stream and express your thoughts? Listen, if you feel strongly about Judge Jackson Brown in any way, or to Judge Brown Jackson, excuse me, in any way, right, you should come up and express that, especially those of you who have felt that this latter half and the talking about her decision, especially if you feel that she's been mischaracterized in any way, right? Oh, here we go. All righty. So let me see your transcript. I'm adding you to the stream now. Hello.
Hello, how are you doing?
Good. How are you?
I am fine. I have been waiting all week for this live of yours.
Wonderful.
I have, because you don't understand, like, I teach history and I also teach, college students as well. And so sometimes besides them, I really have no one else to talk about things like this, like confirmation hearings. And did you see the news? Or if I make a live, I can tell people about it. But it's like, oh goodness, I get to have a conversation. Someone else gets to cover this. Yay! But I was going to ask you about a friend of mine. Well, he's probably the only one I talked to about this stuff too, because we were both political science majors. So it's like, okay, we can talk about this, but he's busy, I'm busy. So it's like, who else can I talk to about this? But he shared an article with me about Tucker Carlson asking for a copy of Judge Ketanji Brown Jackson's LSAT scores. And I'm just thinking, like, to myself,
wow.
the FBI, okay, number one, she's qualified. I heard, I saw, I watched, I showed my students President Biden's speech introducing her qualifications. And I was like, okay, she's Ivy League, with the exception of Justice Amy Coney Barrett, who went to Rhodes College and Notre Dame. So I was like, okay, so she's Ivy League. She's clerked for Justice Breyer. She's done all of these things, right? She's got the resume for this job. She's above exceptional for this job. And this man on TV says, I want to see her LSAT scores. And I'm thinking to myself, don't they have to go? And I remember this from the Clarence Thomas hearings. But the FBI has to do an investigation on you, right? When you get nominated for this job, they got to do a background check.
They do an extensive.
So don't you think they looked at her resume and then they're calling her references and they're going through her transcripts and her LSAT scores and all of this stuff? And then there's probably an office, the president's secretary is like combing through the file on her, like, okay, did she make this score? She was on this class. This was what the grade she made. Why does he want to see them? Right. And I'm just figuring out, like, is it me or is he acting like a stereotypical white man, or is a stereotypical man that somehow you are questioning this woman, this Black woman's qualifications when you have been told what they are? You've been told what they are. But you want to see the LSAT scores. Really? I was just really mad. I'm really upset about it. I'm just like, okay.
So let me just give everyone a brief background. The LSAT is the law school admissions test, right? Everyone has to take the LSAT to get into law school. It's just like your SATs, your ACTs in high school, right? It does not at all signify what happened throughout your career. It does not at all signify if you were/are an effective attorney. It's just a standardized test that law schools use to kind of gauge how well you'll do in law school. And it helps them decide if they want you at their school or not. That's it. It does not at all. It has nothing to do with someone's career, especially someone graduated from law school so many years ago.
Like 20 years ago? You wanted to see her LSAT score for 20 years ago? And I do believe if LSAT is by the same people who do the SAT and the ACT, aren't your scores only valid for 5 years? You got to retake the test?
About that.
Okay, so he wants to look at 20-year-old scores.
It's just
for a current job that really doesn't require your score. Just really looking at what have you been doing the last 20 years to get this job. Like, hey, what have you done since grad school? And I'm trying to think, like, what?
Yeah, so I agree with you that it's totally irrelevant. And the LSAT, just like the SAT, has a history of having discriminatory and disparate effects.
Right.
As a test, as an examination, it has a history. And I can tell you, as someone who took the LSAT, there were questions there that had to do with the intricacies of sailing and certain things that happen when you're sailing.
What?
As we all know, most African Americans are not raised in the type of family that can afford a sailboat.
Unless you're, unless I guess maybe you're from the Gulf Coast and you've been on a boat, but that's mostly getting shrimp, or I'm sorry.
I mean, right. And that's totally different type of boat, right?
Your family into shrimping, boating, getting, hunting alligators, fishing. Like, what is?
Right. Right. So it's important to note that not only are her scores not relevant, but the fact that he is referring to that kind of test is also a signifier. It's a dog whistle because we know how those tests work. We know that very often people of color score lower on those tests simply because the questions that are used are referring to things that people of certain backgrounds would know nothing about.
Right.
So, right, he's totally off board.
I'm just trying to figure out, why are you asking about LSAT scores? You didn't say nothing about, well, what about, like you said, like, Leaf, the lawyer who made the letter, said, I'm concerned about her ruling in this case.
Exactly.
That applies to her job.
Yeah, I would have respected it more if.
Why didn't he look at that? But no, let me see her LSAT score from 20 years ago.
Insane, absolutely insane. But I think her confirmation hearings going to be interesting, yes. But I'm not certain that we're going to get the questions that we're interested in getting, but it will be an interesting watch.
I'm sorry, I'm looking at Jang Ho. What is that?
I don't know. I don't know, but everyone can have their own opinion here, so we'll leave that at that.
Okay.
Is there anything else you wanted to say about Judge Jackson?
No, that was the only thing. Was I just wanted to talk to? I guess I'm biased. I wanted to talk to another Black woman about this man's comment about another Black woman. Was I the only one that was upset and angry and wanted to see his third grade report card, his high school report card, his middle school report card? I want to see. Look, I want to see his transcripts.
It was insane, and it's the type of lack of respect that, quite frankly, we deal with everywhere.
Mm-hmm.
So I'm going to end the conversation with this. There are many law firms who will hire a Black attorney, whether female or male, but a lot of times Black female attorney, right?
Mm-hmm.
Later on, tell her after she's been hired that she needs to provide law school transcripts, or that she needs to. So I just want you to know that this is not out. The legal field is one of the most archaic fields in this nation. We are leagues behind in racial equality, leagues behind in gender equality. It's still the norm for a law firm to punish a woman for going out on maternity leave, right? Oh, yes. It's still the norm for a woman to cry when she gets pregnant because she feels like I'll never make partner if I take maternity leave. So it's the norm for a law firm to hire a Black woman and then later on turn around and say, let me see your law school transcript. Or can I have, some extensive writing samples? And it's like, you already hired. You didn't ask anyone else for that.
Mm-hmm.
So, the legal field is an archaic field, and I will see it turned around. I am going to do my part to guarantee that.
Yes.
So,
yes.
Nice chatting with you.
Nice chatting with you too. All right. I'll talk to you later. Thanks for having me up.
No problem.
All right.
All right, everyone. The link is in the chat. I'm going to be with you all for another 15 minutes. So come on up. Hello, iNike. I already explained my opinion on that. So run the stream back a little bit and you'll get my 2 cents on that. The link is in the chat. Come on backstage. Let's have a conversation about Judge Ketanji Brown Jackson, who, as we've discussed, has an extensive, illustrious career, right? She's gone through several steps in the staircase to get where she is. However, there are people with concerns and people who you would not expect, right? Other Black attorneys and Black judges with concerns about her nomination. I'd like to also add that there are quite a few organizations who considered supporting the nomination of Judge Brown Jackson and then withdrew that decision after hearing what Judge Clement had to say. So he made some waves. Okay. B Buccaneer has an interesting comment. So B Buccaneer says, the Supreme Court has never been a bastion of liberalism. That's obvious. In 233 years, we're talking about 3 Black people serving, right? Thurgood Marshall was sworn in by Hugo Black, a former Klansman. Food for thought, okay? Teddy Woodson says, Miss Felicia, do you think the legal world is about justice or punishment? I think that depends, right? We know that in the civil court system, a person can receive damages, both for just basic things such as medical expenses and things like that, but they can also receive punitive damages, which are damages that are meant to specifically punish the person, right? And then we know our criminal justice system is a dichotomy as well, right? Part of it is pay your debt to society, but the other part of it is, can we punish you enough that we deter you from, being a repeat offender of crime? So I think it's both. I think it's a bit of both. All right. I'm going to put the link in the chat again. Listen, again, all of you folks who are in the comments and in the emails, come on backstage and let's have a chat. To anyone who's catching this on the replay, I want to hear from you as well, y'all. Tell me, what do you think? Do you think that Ketanji Brown Jackson is the one? Do you think that if she were to take the bench of SCOTUS, that she maybe would be someone that communities of color would be supported by, right? Or do you think that, as it's being alleged, she is more so of a corporation, kind of corporate minded person, and that she may just be more likely to uphold the status quo, right? Also, tell me, do you think that she's a purist, right? Like a Scalia or a Thomas? Or do you think that she is more of an activist, like a Sotomayor or a Ginsburg? All right. Let me know what you think. I want to give a shout out to Rockin' with the Truth. Rockin' with the Truth says, thank you, Empowered Esquire, for this information. I work in corporate America dealing with mergers and acquisitions, and I'm loving this conversation. Yes. All right. Kudos to you, Rocking with the Truth, because mergers and acquisitions are no joke. Okay. You want to talk about intricate work. You want to talk about work that challenges you mentally, right? So kudos to you. All right. Kudos to you. Jang Ho says Black women need representation. I second that. All right. Empress Kaya. Hello, lady. She says she could be a little bit of both. Yes, she could be both, right? She could also be moderate. Judge Brown Jackson could be, in some moments, an activist and in some moments a purist. Yeah, that's an option. She could be a moderate. She could be someone who is a little bit of both. All right, so listen, I'm going to drop the link one more time. And I'm going to give you all a few minutes of us having a talk to see where you are with this. But if no one comes backstage in the next few, then I'm going to head out. You know, it's Sunday night, so I'm going to go and wind it down. All right. So listen, I want to have a larger conversation with you all about judicial selection, right? And about why I'm so encouraged by you all being here today. Listen, this is so important, everyone, because as you all heard, judges police themselves. So you need to pay attention to who is becoming a judge and where, because very often, once somebody takes that bench, it's the wild, wild west, baby. It's over. There's nobody there to police them and check their behavior. Okay, you have judges policing judges. And as we heard, very often that equals no discipline at all. Okay, judges at this point, a lot of them are getting away with whatever they want. So I am grateful for each and every one of you here. And I'm so grateful that you care, that you're interested, that you want to have this conversation. It says so much, y'all. It says that we are awake and alert and we care. And we have to be, because we have to pay attention to what is going on in the judiciary. Similar to law enforcement, once you are in the judiciary, you are in. Many of these judges are federally appointed, meaning the only way to get them out is to impeach them. Did you all know that? Did you all know that a federally appointed judge cannot be removed unless you impeach them? Yeah. So this is a vital conversation. You are a part of the solution today. I want you to take a moment, give yourself a pat on the back. Listen, from me to you, because you're a part of the solution today. We have to pay attention to things like this. Okay. All right. I am in the chat. Healthlight made an interesting conversation. She said another way to check her out is to know more about the judge she is replacing. Yes. Remember, we had that conversation that she clerked for Breyer and now she's taking Breyer's seat. Interesting. Asaru says, drop some more videos. Yes, Asaru, I will, boss. I will. But remember, I have a life. I have a practice. You know, I'm not retired. You know, I'm a practicing attorney. So I have to balance. I have to balance, right? So I am at this point trying to churn these out for y'all and doing the best that I can. All right. Okay, all right, everyone. So listen, I don't see anyone else backstage. So I'm gonna go ahead and head on out for the evening. Per my usual, right? Thank you for joining me for another episode of Empowered Esquire TV. You've just watched a real lawyer reacts, okay? And I was reacting to the nomination of Judge Ketanji Brown Jackson. I hope you feel empowered by the legal information that I shared with you today, because you are powerful and amazing in your own right. You bring something to this world that is unique. You bring something to this channel, to my life, that is unique, and I appreciate that. All right. If you're catching this on the replay, what say you? Is Judge Brown Jackson a purist or an activist? Should we be celebrating or should we be concerned? See you soon.